Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back. We're back with the Truth Attack. Okay, so how do we want to do this? Well, we are the Liberty Works Radio Network, and we do need the support of the members of the broadcast listening audience to keep the network operating. So, if you enjoy the information, the lectures, the discussions, the revelations, the hosts, and the guests on the other shows on the network, we sure would appreciate it if you'd find your way over to the LibertyWorksRadioNetwork.com website and get signed up as a subscribing member, even if it's as little as $15, $20 a month. Every membership helps, and we do need your support to keep the broadcast network operating. So, there you have it. LibertyWorksRadioNetwork.com. Help spread the word on the path back to constitutional government, freedom, and liberty. And if you want to get fully informed on the maladministration of by the Internal Revenue Service of the federal income tax, the personal income tax, you need to find your way over to taxfreedom.com and start reading and get educated. And if you know anyone that needs help answering correspondence from the IRS, you send them over to irszoom.com, where they can get help answering any letter from the IRS and answering the Department of Justice in court. And I actually got an update on the way the IRS is operating. I'll probably get to that maybe in the third segment of the show today. But first, let's get into this. I was playing around with AI a little bit and asked it to lay out a plan for defeating the federal income tax based on the information provided at taxfreedom.com and irszoom.com. And this is what it came up with. Let's get right into this. Here is a cost-effective grassroots plan designed using the legal theories, educational frameworks, and resistance strategies championed by resources like irszoom.com and taxfreedom.com. The core philosophy of this plan relies on the premise that the federal income tax on the domestic wages of sovereign citizens, American citizens, is an illegally enforced, unapportioned direct tax that is unconstitutional, and that compliance with said tax is fundamentally voluntary, but sustained through coercion and public deception that amounts literally to extortion of the American people to pay a tax that is not imposed, is not deposited in the Treasury after collection or payment, because it's not a tax. It's a peonage debt service system. All the money taken from your pay is sent to the Federal Reserve Bank to collateralize the $40 trillion in debt run up. None of it goes to the government. None of it pays for the administration of anything the government does. It all goes directly to the Federal Reserve Bank around the Treasury in violation of law, because Section 7809 says every penny of tax collected has to be deposited in the Treasury. And that, of course, is because tax is money for the government to spend, and if the money isn't in the Treasury, Congress can't write appropriations against it to spend it. And only Congress can spend it, and they can't spend money at the Federal Reserve Bank, and because it's not in the Treasury, it means when they need money, they have to borrow more from the Federal Reserve Bank instead of using the tax revenues that would have accumulated in the Treasury had the deposits been made to the Treasury as required by law of all tax. The fact that no Treasury deposit occurs is why you have no credit for tax. Even after 12 months of withholding, there's no credit for tax until you file a return on April 15th. That's why you have to file, because there is no credit of any tax paid. They took all that money from your pay. There's a law that requires it to be deposited to Treasury, and yet there's no credit for tax in your name as required by that law of all collected tax. So it's not a system of taxation. It's an unconstitutional system of compelled peonage debt service, where the American people have been reduced to the role of the peons who must service the debts of their masters on the hill running the plantation. It's the peonage plantation system from the 11th century, folks. There's no tax involved. It's compelled labor to serve the global elite that run the planet and print the money and then steal it from you before it can be exposed by inflation as being worthless because of your spending. Okay, so let's get back to the plan. Phase 1, grassroots education and paradigm shift. The most cost-effective weapon against compliance is widespread education and awareness. The government relies on the public's ignorance of the tax code and lack of awareness of the big picture, and the lack of knowledge of constitutional law. They rely on all this ignorance of the American public to take advantage of them to extract their wealth, i.e., that portion of your paycheck you never see, but which never goes to the Treasury. It goes on, exposing the 16th Amendment myth. Distribute digital packets and hold local seminars showing that the 16th Amendment did not grant the government new power to impose direct, unapportioned taxes on labor. Well, now, I'd agree with that, except, going around doing seminars is expensive. You got to deal with the travel and all the production. I think the internet is a much more effective way. We just need help sharing the information and getting people to understand that this information is all available on the internet at taxfreedom.com. And all you got to do is go read it. I shouldn't have to go around the country and do 1,000 lectures to audiences of 100 people. We should be able to get 10 million people to go read the website because they've been reduced to slaves and aren't taxpayers. Because none of the money goes in the Treasury and isn't funding the operation of the government. It's collateralizing the borrowing of worthless fiat notes in place of using real currency in our society. Okay, so educate the public, expose the 16th Amendment, which is a complete and total fraud, showing that the 16th Amendment did not grant government new powers to impose direct unapportioned taxes, and that's what they have claimed for 75 years. The income tax is a direct unapportioned tax without exception, that is unavoidable, that is authorized by the 16th Amendment, despite the fact that there's no enabling enforcement clause in the 16th Amendment to authorize Congress, constitutionally authorize Congress, to write law to enforce that new power to tax. And of course, if the courts can't show that Congress is constitutionally authorized to write the law to apply to the power allegedly that exists, well, if Congress wasn't authorized to write any law, the court can't help them because the courts can only enforce law that Congress is constitutionally authorized to write. Article 1, Section 8, Clause 18, Congress shall have all powers necessary and proper to carry out in execution the foregoing granted powers. All the other amendments have an enabling enforcement clause authorizing Congress to write law for the new power granted by the amendment, wherever the amendment was intended to create a new power that would be enforced against the people. Oh, all the amendments except the 16th Amendment, which is probably one of the reasons why the Supreme Court originally ruled no new powers are created by the amendment. No new parties are taxed. The same people that owed the tax before the amendment owe it now. Corporations, foreigners, licensed persons, and persons in territories and possessions. Impost, duty, and excise. That's it. There's no direct taxation, and there can't be once you understand that the 16th Amendment is incomplete as a grant of power. It appears to grant a new power, but it does not grant Congress authority to write law to administer to or enforce that power. It's a fraud and has been since the beginning. And it actually wasn't used against the American people until after World War II. They got their foot under the door, or the camel's nose into the tent, with the victory tax, taking advantage of the emergency of the war to violate the Constitution and attach themselves to the labor of the American people. And if anybody complained, what are you, a Jap or a Nazi? And they locked you up in the internment camps. So nobody complained. And they got away with it. And your victory tax lasted for 2 years and expired. And then they kept withholding the tax even though there was none authorized anymore. So, the next section, Phase 1, Education and Paradigm Shift, Redefining Income. Teach the public the legal distinction between wages and equal exchange of labor for compensation, value for value, and income, which is corporate profit or federally connected privileged profit. Impost, duty, and excise. Income isn't the object of the tax or the subject of taxation. It's the yardstick that measures the amount of tax owed on the revenues derived from the activity and transactions subject to federal taxation under Article 1, Section 8 by impost, duty, and excise. Impost tax is foreign persons, foreign imports, and in foreign places. Duties tax exports, and excises tax the manufacture, consumption, and sale of commodities within the country, things like alcohol, tobacco, and firearms. Licenses to pursue certain occupations, like selling alcohol, tobacco, or firearms, and the corporate privilege, where it is the privilege that is the subject of the tax, not the mere earning of money, which would be a direct tax. It's the privilege, and income measures the amount of tax owed on the revenues derived from the enjoyment of the privilege. It's not a direct tax on everything the American people do. It never has been, never was. So teach the public the legal distinction between wages and income. And once the citizens realize their labor and all their other activities in the states is property and earnings that are not taxable indirectly by impost, duty, or excise. Not corporate, not impost, not export, not import, not license, not foreign. Once people understand this, that there is a territorial limitation to the federal powers, which is also not overcome by the 16th Amendment. Phase 2, severing the withholding nexus. The government funds itself by extracting wealth before the worker ever sees it. Halting this system at the source starves the mechanism of illegal enforcement, voluntary enforcement. The W-4 Exempt campaign provides step-by-step guidance for employees in the private sector submit new W-4 forms every year to their employers claiming the exempt status based on a lack of liability for tax in Subtitle A, just like it says in Section 3402N, which is the supremacy clause in 3402, defeating 3402A's apparent mandate for the employer to withhold tax from everyone. But 3402N overcomes that apparent mandate, as it is the supremacy clause. A is a clause of subordination. N is the supremacy clause. 3402N, claim exempt, you're not liable because the only liability for tax in Subtitle A is that of the withholding agent, the collector, under Section 1461. There is no other statutory liability to allege you owe. It doesn't exist. Okay, I think I hear that first commercial break coming up here. This is Thomas Freed on the Liberty Works Radio Network. We'll be back in 5 minutes with more. And we're going to continue this conversation about how to defeat this. Okay, this is Thomas Freed on the Liberty Works Radio Network. Let's just get right back into this. We were interrupted by the commercial break there. We were going through phase 2, and I think the last element was the W-4 exempt campaign, where I explained how you have the right to claim exempt on a W-4 every single year, and nobody has any legal right to change your claim. No one can force you to pay a tax before it's legally due. That would be violating the 13th Amendment's prohibition on involuntary servitude, forcing you to pay or service a legal obligation that does not yet exist, is only a future potential obligation, and may never exist at all, cannot be compelled. No one can compel you to pay a tax that isn't due until next year, April 15th. That's why the W-4 is titled as an employee's withholding allowance certificate. You're allowing it. You're giving them their permission. Hey, if it's a tax that they have to collect, why the hell are they asking for your permission to withhold it from your paycheck? Because they have to have your permission, otherwise it's involuntary servitude, forcing you to pay a future obligation that does not yet exist as an obligation that you can be compelled to pay. That's unlawful conversion and conspiracy in violation to rights. You have a contract that says your employer has to pay you everything that you've earned. You can't send half it off to the government unless you ask them to and allow it. But if you revoke your allowance because you have no liability for the tax under Subtitle A, because you're not a collector who collects tax from withholding agents, from non-resident aliens as a withholding agent, you're exempt. You should take your whole paycheck home and tell them to go to hell. Why should they get a third of your paycheck? Go to hell! Prices have gone through the roof. I need my money. I'll deal with April 15th when it comes. Pay me what I'm owed. Okay, next element, revocation of presumed consent. Now, this is not something that I advocate on the website. This must have been a side thing that AI linked to and found. But this is not something. Equip citizens with templates to legally rescind any presumed election. No, that means nothing. There is no presumption. Anything rescinded has nothing to do with what happens in the future. You can't alter future obligations under the law by altering the past or attempting to alter the past. Doesn't work that way. What you can do is answer every document you get from the IRS with a letter that cites the law back to them, educating both the Internal Revenue Service and yourself. That can all be done at IRSZoom.com, and that's what we have done, is equip citizens with templates to answer with law anything that comes from the IRS or the DOJ. Okay, you can't revoke signatures from past documents. It doesn't mean jack. They don't recognize that this is a frivolous argument. You can't rewrite the future and duck obligations that may occur. Because if you go do business in a territory or possession, or if you start selling alcohol, tobacco, firearms, or nowadays marijuana or other substances, you could be subject to the tax. It won't certify anything going into the future, and nothing you can change in the past will alter your status going into the future, which is based on, or going to be based on, the transactions and activities that you engage in that are subject to indirect taxation under Article 1, Section 8 by impost, duty, and excise. That's what will control what you do that's subject to federal tax. And as soon as people get educated to understand that, perhaps we'll be able to start winning in jury trials, and that will shut down the system. If they can't win in jury trials, criminal nor civil, that pretty much is the end of it. So people need to be made aware. The whole thing is a fraud. It's not a direct tax. It's limited, and income has been used to lie to the American people, to convert the corporate profits to anything any person owns. Oh, because we're all persons, that's right. No, just because we're all persons, it doesn't mean you can be treated like a corporation and everything you do is taxable. And this is, of course, where the corporate name capital letters argument comes in, which is also nonsense. They're not treating you like a corporation to tax you and putting your name in capital letters to make you think or to treat you in court as. It's not what's happening. That's not the way it works. The way it works is they claim you owe the tax because of the 16th Amendment. It's a direct tax. It's unavoidable. It's on everybody and everything. Your status or non-status as a corporation is completely irrelevant to them. They're laughing at that. That's not the argument. The argument is unavoidable direct taxation under the 16th Amendment that operates on everyone. Oh, you made me a corporation by putting it in capital letters so that you can tax me indirectly by excise as a corporation? They have never, ever, ever made that argument in court. But they argue in court, 16th Amendment, direct non-apportioned tax, unavoidable on everyone, no matter what you do, no matter where it comes from. We suddenly are the authority in the 50 states over earning money. Or where the hell did that come from? Oh, the 16th Amendment. Okay, this other phase 3, affidavits of truth instead of standard tax forms, encourage the filing of sworn affidavits. Again, this is not what I recommend. You don't want to file things with the government making claims. Nothing is required. There's nothing you can file that will change their beliefs and arguments about the matter. And anything you add to it that's wrong, or even if it's conceived improperly, they'll just laugh at you and use it to make you a target. You're better off giving them nothing at all than anything that makes any argument. Make them make the argument, because they can't. Not properly. They can't show what form of tax is being applied. They just produce, oh, look, you made money, earnings. Objection. No foundation, not best evidence. Where's the foundation? What kind of tax are we talking about that those earnings are subject to? Was it an impost because I'm foreign? Was it a duty because my labor is an export? Is it an excise because I'm a commodity? I'm sorry, Title 15, Section 18 says the labor of a human being is not a commodity or article of commerce. That removes labor of citizens from excise taxation. Labor unions had Congress write that statute in the middle 30s when they saw them coming for the labor. And then they let it happen in World War II and haven't said anything since. I guess that's because the government let the employer withhold for the union. Oh, that shut the unions up, didn't it? No more protecting the worker. Now we're protecting the unions because we're getting rich off the worker too. Just like the government. Oh, no, that's what you call representation, right? Representation. Oh, my God. Phase 4, asset protection and jurisdiction denial. To prevent the IRS from utilizing levies or liens, the American people must learn how to structure their property outside of federal jurisdiction. Common law trusts, I actually don't advocate common law trusts. They get ignored. You have to do real trusts, not common law. They have to be declared and executed properly. But educating individuals on how to place homes, bank accounts, and vehicles into private common law trusts or unincorporated associations, that won't work for you either. The government just runs right through all that stuff. This must be only coming from things that are linked to the website, because some of these are not programs that I advocate for. But we do want to fight them in court. Whether they file civilly or criminally, you challenge jurisdiction. Now, asset protection can be done by putting property into a real trust that is properly administered to and files its own tax returns. And this is what Lynn Meredith used to pitch as pure trusts. And the only thing that a pure trust is a trust that earns no money. All it does is sit there as the custodian and holder of property. And it pays the tax on the property, but it doesn't earn any money. And because it doesn't earn any money, it's just a fiduciary custodian. It's a pure trust. There's no earnings, there's no tax, there's no income. Although it has to file an income tax return, there are no earnings to report, so there's no tax. There's only education. There's only expenses. And the trust always runs at a loss, a small loss, the cost to administer to it, which is generally assumed by the trustees. Okay, so non-compliance with administrative summons. This too, we would argue, is correct. You supply citizens with the pleadings and legal scripts to lawfully refuse IRS audits and summonses. By asserting Fourth Amendment protections against unreasonable search and seizure and Fifth Amendment protections against self-incrimination, citizens can refuse to open their private books to administrative agencies, forcing the IRS to prove liability without the citizen's coerced testimony. That's true, but the way that I prefer to oppose the summons is by going after 7608A and B. 7608A says IRS revenue officers and agents can serve summonses under Subtitle E, Alcohol, Tobacco, and Firearms Law Enforcement. 7608B says only a criminal investigator of the Intelligence Division can serve a summons outside of Subtitle E, like in Subtitle A, income tax. But a criminal investigator of the Intelligence Division, intelligence tells us it's foreign. He'd only be investigating foreign matters that a citizen might be involved with, never the citizen himself. And a criminal investigator doesn't issue summonses because that tells the target he's being criminally investigated, and that, of course, can often motivate the target to suddenly lose everything that they had. There was a fire. Yeah, it was a small fire in the fireplace, but there was a fire. It got out of control. Everything in the room burned up in the fireplace. No, really, you should have seen it. It was amazing. So they don't serve summonses as criminal investigators. They keep the criminal investigation secret until they're ready to go to the grand jury with enough information and accusations, data, and facts to secure an indictment from the grand jury. So summonses are pretty much reserved for corporations, licensed folks, commodities, and foreigners. But people don't argue this properly. The Fourth and Fifth Amendment aren't really defenses against an IRS summons. They're not the proper defense. I know they should be, but the courts have dismissed them, using cases that invoke the authority to summons corporate records, which they then picked up and dropped on top of individuals as though they were corporations, without admitting the difference between the corporate facts and the individual facts in the two separate cases. You can't apply a corporate ruling to an individual because the corporations agree to give up their books by virtue of the incorporation. Citizens never make that agreement. They have the Fourth Amendment right. So, 7608 is the section to go after the summonses. And of course, subject matter jurisdiction is how you go after them in all civil and criminal cases. Using Moore to controvert the circuit court precedents that they've been invoking for 50 years, which are all rendered moot, irrelevant, and overturned and overruled by Moore and its holdings. Okay, so phase 5, legal gridlock and jury nullification. I think we're coming up. We'll be back in 5. doing here? Okay, this is Thomas Freed, all the Liberty Works Radio Network. Let's just get right back into this discussion here, where we're looking at step 5, legal gridlock and jury nullification. The final step makes the enforcement of the fraudulent tax economically and physically unfeasible for the government, overwhelming the system. If millions of Americans concurrently adopt these lawful pushback strategies, the IRS, which operates on limited resources, manpower, and relies on 99% plus voluntary compliance, well, at least for the 50% that pay, will face complete administrative gridlock. They do not have the manpower to investigate, audit, prosecute, or enforce mass non-compliance. And they can't automate it. They've put steps into the law that require them to deal with individuals. If they had to give a collection due process hearing to every person they issue a notice of levy or lien to, they'd be backed up for 10 years on CDP hearings, and nobody would have to do anything with the liens or levies, because you have to have a determination from the hearing before you can enforce the instrument, as long as it's contested within 30 days of issuance. So, which is why they often issue the lien, file it at the courthouse, and don't give you a copy. So 30 days will expire before you ever even know there's a lien that you can contest with a hearing. So they don't have the manpower to enforce if millions of people say, you're lying, it's a fraud, I'm done with your slave system, pay me what I'm owed, or get sued for conspiracy and unlawful conversion. You can't turn my property into debt service for the Federal Reserve Bank because Congress owes money to the bank, a private corporation. We have no responsibility for Congress's debt. They ran it up. Let them pay it. We got no business dealing with those. It's a fraud. The bank is a constitutional conspiracy to rule America. And of course, the government has unlimited money, unlimited access to the printed money, and uses it to rule rather than to represent. And it's buying votes of the ignorant, intentionally kept ignorant, and foreign, incapable, uneducated, unskilled, unasseted, unpossessed, unable to exist without the largesse of the welfare system and the support of the hardworking American. So they're importing the welfare voters, foreigners, for the American taxpayer to carry. All just nonsense. Okay, so overwhelming the system. They do not have the manpower. Let's go on. Jury nullification. Launch an aggressive public awareness campaign regarding the rights of the jury members. If everyday citizens serving on juries understand that the direct income tax is fraudulent, they can refuse to convict their peers of tax offenses or to side with the government in civil foreclosure asset cases, regardless of the judge's instructions. A few high-profile acquittals would shatter the illusion of IRS invincibility and permanently break the system of fear. So the problem there, of course, is that attorneys won't argue anything. The attorneys don't argue any defense under the law. They only argue facts and exceptional character. You know, don't punish this guy. He's not such a bad guy. The attorneys don't put up defenses. They always say settle, take the deal. So these arguments never get put in front of a jury criminally. And civilly, the government has been bypassing the juries, granting summary judgment whenever subject matter jurisdiction or liability for tax or requirement to file a specific tax return based on the law, whenever those issues come up, they just skip the issues and grant summary judgment. So there's no jury for the seizure of the home. Well, they can't get away with that with criminal. They have to have a jury if it's demanded. But again, the attorneys won't make the arguments, and criminal defendants always want to argue their own thing instead of the proper and limited application of the law, which is all laid out in my, let's go look at that. It's all laid out in the 71 exhibits that we have to, this is the Thomas Freed channel on YouTube. I've got it labeled as income taxes terminated, but right down here, we have the, let's roll it up to the top here, right here, under the federal personal income tax fraud exposed, I have the introductory on subject matter jurisdiction. And then I have the 4 videos that work their way through 71 pages. Each video is about 45 minutes, as I recall. They work their way through the 71 exhibits that are designed to be presented to a jury at trial, step by step. Here's the law that I know, that I am aware of, that I use to guide my actions before refusing to do what the IRS is demanding. Here's the law. I have the right to show you the law about what I believe, and if the law is reasonable and you see that it's coherent and consistent and a good argument from what the statutes say, well, isn't that reasonable doubt about intent and knowledge of the law? Well, particularly when you consider the government can't show them anything in the law that you haven't already shown them first. Because they don't base their case on the law. All they do is show a record of earning and say, look, he made all this money and paid no tax. There's no law involved. They don't argue law. So here's the 71 exhibits all laid out. And of course, I lecture on it every week. Here's the Truth Attack Hour exhibits down here. And we have all the documents at irresume.com right over here in the store. For examination, summons, assessment, collection due process hearings, Privacy Act requests to get your data, employers and withholding. You need a letter that you don't see here, contact me. I'll write it for you if I don't already have it, because I have a number of letters that just aren't available through the website yet because I've written them, but I haven't mounted them as a product. But I have them. And I also have state tax responses for all of these states: Alabama, Arizona, California, Colorado, Georgia, Idaho, Illinois, Iowa, Louisiana, Maine, Michigan, Montana, Nebraska, New Mexico, New York, North Carolina, Ohio, Oregon, South Carolina, Utah, Virginia, and Wisconsin. I think I have a few other states too, and they also haven't made it into the list yet. But we have letters that answer every single one of these state tax agencies with the state law. And we show how the state law is based on the federal law, specifically Section 61, gross income, which was enacted in 1918 under a Canadian tax treaty. It's never been enacted as domestic legislation. It was enacted 5 years after the Tariff Act, which is also not domestic legislation, other than the fact that it applies to foreigners in the 50 states. But as a tariff, the Underwood-Simmons Tariff Act of October 3rd, 1913, that's the original income tax legislation. As a tariff, it's an impost. It only applies to foreign persons, foreign imports, and in foreign places like the territories and possessions where the 1939 law shows us the tax applies, right? We've all seen that, 1939. And the statutes at large. And we roll down to where it shows us, oh, there it was. Nope, went too much. Come on, move up. The computer seems to be having issues today, doesn't it? Oh, come on. Okay, well, here we can see it's coming on the screen right now. These are the groups of persons subject to the collection of the tax and the payment of the tax. Great. Right? We got the special classes of taxpayers, estates and trusts, members of partnerships, insurance companies, non-resident aliens, there's the foreign corporations, those are the tax collected by the withholding agents that collect money from foreign persons, non-resident aliens and foreign corporations. And there it is. Those two groups are subject to the tax. Partnerships and companies subject to the excise. Individual citizens of any possession. So if you're a citizen of a possession and earning money, individual citizens of the United States earning a large portion of their gross income from sources within a possession. It's all foreign, territorial, non-resident aliens, and foreign corporations. That's who pays the tax. You got China Trade Act corporations, foreign personal holding, mutual investment. Now this is all from the 1939 Statutes at Large, which is the 1913 law published in the statutes 26 years later. They got it all there 26 years later. There's nothing missing. The income taxes right here, Chapter 4, special classes. There are no regular classes because this is a special tax. It's a tariff. There's an impost. Only certain persons are subject to it. And all of this is quite clear, 100% in the 1939 Statutes at Large. The government's been hiding this, and they recodified everything in 1954 to change the statute to section 61 and alter it so that people began to believe gross income applied to everything that you made in the states because it's a direct tax that all the states piggyback as a direct tax. They're all violating the Constitution. Not a single one of them can explain what they're doing other than the 16th Amendment, which, of course, the Supreme Court decision in Moore says is a lie. There is no such thing as a direct tax. This is the Moore decision. That says the income tax is an indirect tax. It's the syllabus, it says right here. Held, Article 1 of the Constitution affords Congress broad power to lay and collect taxes. The power includes direct taxes, those imposed on persons or property, and indirect taxes, those imposed on activities or transactions. Taxes on income are indirect taxes. And the 16th Amendment confirms that taxes on income need not be apportioned, only uniform, because they're indirect. But how is graduated taxation uniform with respect to citizens? It isn't. And citizens can't be broken into different classes based on levels of earnings the way corporations can. When graduated taxation was adopted in the 1880s, it all applied to corporations and foreigners. Graduated non-uniform taxation of citizens is patently unconstitutional. And there is no direct income tax that exists. And there is no income tax that applies to anything you earn in any of the 50 states. And none of the money goes to the Treasury. It all goes, surprise, surprise, to the Federal Reserve Bank. A private corporation that's cashing your tax check. You don't believe me? Take a look at the back of the last check you sent to the IRS with your Form 1040 on April 15th. See if it says on the back of that check, deposit to the U.S. Treasury, or if it doesn't say pay to any FRB, Federal Reserve Bank, a private corporation. Why is a private corporation cashing your tax check? Because it ain't tax. It's peonage debt service. We'll be back next week with more. This is Thomas Freed, out.